I want to mention that there is a bit of a problem in this area because once OSHA is there and you open the door for most everything. So if OSHA is on the work site because of a search warrant, contact your attorneys, let them know, and let OSHA through to do the inspection per their warrant. However, if they ask you, can they have your permission because they don't have a search warrant, contact your attorney and follow that attorney's advice, which is often no. Without the search warrant, the government shouldn't be intruding. So the reason why it's a no is because once they're there, they can find not just one problem, but a host of problems. If they come for one issue, and even with their search warrant, if they come for one issue, and you open the door, so to speak, they can find other issues. And here's how it would work. Let's say they have a search warrant for one particular part of the plant. It's a building because of an injury or worker's complaint. And then they say, well, while we're here, let's just look around. Do you mind if we look at other buildings? That's where the search warrant doesn't apply. That's where the attorney needs to be notified. And again, likely you would say from your attorney's advice, no, you need a search warrant. Because if there is something else, they can cite you. And because you gave them permission to be there, there's no, you waived your right to the privacy in that regard. On page 198, the book mentions a security audit. I put those in the same category as risk audits. In other words, where are we as a company exposing ourselves to liability for workers' injuries or workers' illnesses, work-related problems? Include in your risk management survey or audit the security audit, which is where do you find in the plant that there may be problems of access for the police or the fire for rescue. Is there a problem with crime in the surrounding neighborhood? And do you need to protect your workers like anyone would? And so the liability actually falls from what we refer to as owners or premise owners or premises liability. If you are the owner and you invite people to your premises, you have actually a greater burden to make sure that any problems are solved. Anything that's a risk is minimized. And I don't want to get into all of the details there, but most of us understand that owners bear some liability to those people whom we invite. And that's true for an employer and an employee, as the employer invites the employee to the premises to work. I want to mention in passing too that there are a number of issues with regard to employment contracts. You can have for term contracts or you can have at-will contracts. At-will is what most people do with wage earners, where you work at your will, you leave at your will. The employer hires you at his will or fires you at her will, which doesn't exclude unemployment, but it just says that your contract is a day-to-day deal. So if I'm working at McDonald's, every day is a contract. However, if I am a unionized shop or I'm a general level manager or some other type of talent, I might have a contract for a period of months or a year. I might even have, as an executive, a period of 3 years, which is not abnormal. So employment contracts, just be careful that you understand what that is, because Washington is an at-will employment state. Let's move on to issues that bear more discussion, which has to do with discipline. The last discussion, I think, deals with discipline, and this is the one where you have to be careful. What I think is best, most employers do, is what we call progressive discipline. First strike, second strike, third, whatever. Immediate discharge is only basically there for just cause for discharge that is severe. In other words, what the employee did was very severe, very harmful, and immediate discharge is the only option. Most of the time, though, you don't have that type of behavior, and so what you want to do is rehabilitate the behavior of the employee by giving that individual verbal warnings, written warnings, possible suspension with or without pay, but the right to come back. I think in this case too, you want to inject training, if training can be a way to remediate the employee's behavior. Sometimes training works, as I said earlier, sometimes it doesn't. But discharge is the final step. Termination is usually a matter of last. And it's because, again, we go back to one of our earlier discussions, hiring a new individual can be very expensive for HR, for the line managers, for everyone. Also, dealing with unemployment can be very expensive if you contest it, if they felt like the employee was fired for just cause, that rules out the individual's chance for unemployment insurance. But if they contest it, then you're in that administrative process. So additional cost, additional time. And so there's also a possibility that there's an EEOC violation that you've caused by the discharge that you weren't aware of. And so you really do want to have a progressive approach to provide both the employee and you as HR an opportunity to work this matter out without having more issues come out of a final termination.